All right, once again, it's on. Happy Sunday. It's a beautiful Sunday afternoon. I just want to thank you for coming through and pulling up. We're going to be talking about this Young Thug case. As you probably know already, this man, Jeffrey Williams, was arrested on May 9th. And so we're going to be talking about the bond hearing that he had this past week where he was denied bond. And a lot of people are talking about it. A lot of people are talking about this case because it's another situation where it sounds like hip hop's on trial, lyrics are on trial. You got a lot of people crying out and being upset about the idea that Young Thug and Gunna are being dragged through the criminal justice system based on their raps. And so we're going to get into that a little bit. And so let me know. I want to hear from you guys in the chat. Let me know, what do you think? What do you think about this case? Is it just about the lyrics? Do you think Young Thug's being unfairly treated? Do you think Gunna's being unfairly treated? I'm curious to hear what your thoughts are. And so before we actually get into it, everybody for tuning in at the last live. So we did the Bill Cosby sexual assault trial that he has going on. We're breaking down that. And then before that, we had Nipsey Hussle, and those views are going up and up and up. And so I just want to thank you, as always, for the support. But yeah, the topic of conversation today is going to be this Young Thug bond hearing. And so we're going to be going through quite a bit of information because, this is an interesting case to follow. And so yeah, here we have the headline. So we actually had, there were hours of this bond hearing live stream. So there were multiple witnesses who testified. We're going to get into some of that witness testimony. We're going to get into the Georgia law and how that applies to this situation. Again, I saw there was, at least 4 hours of live stream information on this bond hearing. And typically when you have a bond hearing, I mean, you can have a bond hearing that lasts, just mere a couple minutes. You could have, a 10, 15-minute bond hearing, or it can be a little longer. But this thing went on for hours with multiple witnesses. So not only are we dealing with somebody who, isn't your average person that's charged with a crime. Obviously, Young Thug is an award-winning artist and, multimillionaire and a standout figure, somebody who's known around the world. So this is a different situation, but you're going to see there was a massive amount of support in the effort of getting Young Thug out on bond, which unfortunately was not successful. But just backing up a little bit, we're going to talk about the indictment, because I think a big thing in the community is this outrage about whether Young Thug is only being prosecuted because of his lyrics. And so there's a lot of fear amongst the artists out here about, well, if I'm talking about certain topics on my raps, am I going to, potentially put myself in danger of being arrested or under investigation? And I think if that is a person's concern, I would just say that probably isn't very likely, because as we see, there really is going to be a marriage, if you will, between some of these lyrics and some things that have actually taken place. And again, at this point, we're only talking about allegations. Nothing has been ultimately proved in court, and as will be, conceded by the prosecution or, by the judge in issuing his decision, saying, hey, these Mr. Williams and everybody else in this indictment enjoy the presumption of innocence. So they are innocent until proven guilty. But ultimately, obviously, he made his decision. So we're going to break that down because, there's just a lot of ignorance. And I say that with all due respect, but there's a lack of knowledge in terms of how these things work. What does the law say when it comes to bond? What is the judge looking at? What are the standards that are put forth, and what does it ultimately mean? So I think this discussion, it probably makes the most sense to start with a look at the indictment. So we're going to take a quick look at the indictment. It's 88 pages, so we're not going to go through every single page, but I think at least getting to some of it will be definitely of use and helpful. So let me get here back to page 1, because I was looking at this a little earlier. And so So this is the indictment. All right. And so as we were talking about before in the breakdown of the Nipsey Hussle case, an indictment is ultimately what comes after a grand jury proceeding. All right. So the case is put in front of a grand jury in order to determine whether a crime has been committed and whether the person accused is, the one who committed the crime. And so this is a probable cause hearing. And like we talked about last time, a lot of times when you're dealing with high profile figures, or even in a situation where the evidence might not quite be as strong and you just want to, you as a prosecutor want to get a preview of how a jury is going to react to the evidence, then you might, in that situation, put the evidence in front of the grand jury. And so there are no defense attorneys in the grand jury proceeding. There's, the DA who's presenting the evidence, and then there's often what'll be like a grand jury representative who's also from the DA's office, who's basically ensuring the fairness. They're kind of guiding things along. If anything, they kind of serve as the judge in the proceedings, but there is no judge there. And so ultimately they put on this evidence. So by way of witness testimony, you can have law enforcement officers there. They may have witnesses who are actually members of the organization. So in this case, we're dealing with conspiracy to violate RICO, and the basis of that is this group YSL. So and you've probably heard throughout in different articles and different videos that there is this YSL as the record label, so Young Stoner Life as the record label, and then you have YSL as the actual gang or the actual criminal organization, which we'll be getting into in this indictment. And so as we go through the indictment, there are, there's some real-time serious crimes in this indictment. So, you're just going to see out the gate that there's not necessarily, this isn't just, okay, Gunna and Young Thug have rapped some lyrics, and so now they just all of a sudden find themselves facing criminal charges. No, I mean, there's actual offenses and serious ones that have been committed, and ultimately the prosecutor is just saying that, hey, with respect to these lyrics, these are just what are called overt acts in furtherance of this whole conspiracy. And so when we look, right after count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, boom, the next one is murder. So at some point, somebody within this organization killed somebody, and there's a murder charge. And so we have armed robbery, we have aggravated assault with a deadly weapon, possession of a firearm during commission of a felony, theft by receiving a stolen property, violation of the Georgia Controlled Substances Act. So we have some drug offenses here. And here on the left side, you just have all of the individuals who are named in the indictment. All right. So we have more armed robbery, aggravated assault. So this long string of offenses are what's being alleged. And then we have, we obviously have Sergio Kitchens, Gunna, so one of the famous individuals in this indictment. And then obviously we have Jeffrey Williams, aka Young Thug, aka Slime. And so again, participation in a criminal street gang, possession of a firearm, attempted murder. So we have attempted murder and actual murder. So again, when it comes down to this string of offenses that we have, and again, it's very important to emphasize and reiterate that every person named in this indictment is innocent unless and until they are proved guilty, either by way of them pleading guilty, right? So them entering a change of plea from not guilty to guilty, and thereby the government would get the conviction that way, or by way of them going to trial. So we know that trial is set for January of next year. So if they go to trial and they're found guilty, so then that's how they would be convicted. But unless and until either one of those things happen, a guilty plea or a jury finds them guilty, they are innocent, and they enjoy the presumption of innocence throughout these whole proceedings, including this bond hearing. But yeah, continuing forward and just pointing out a couple of issues here that will be relevant as to Young Thug, because we're just talking about Young Thug and this bond hearing and the denial of the bond hearing. So coming here Again, because this is information that, yes, if you've already done some research or looked at some blogs or watched some videos, you may have this information, but this may be the first time that you're actually seeing a copy of the indictment. And I guarantee this will end up being eye-opening, if not informational, informative, and possibly entertaining, just seeing how this whole thing works. I mean, at the end of the day, if you may already have a relationship with me, but if you don't, I am a criminal defense attorney. I practice in San Diego, California. Kersey law is my practice, and I've defended all kinds of cases, including federal conspiracy cases, major drug crimes, homicide, basically you name it, I've defended it. And so I'm here providing some insight that, that is relatively rare, that you're not going to find in other places. And so I want to go through this stuff and kind of give you my reaction, give you my thoughts, and even answer some questions as we go throughout this. So yeah, focusing on part one, the conspiracy. So they're saying, as associates of the enterprise, Young Slime Life. So that's the alternative definition. So we have Young Stoner Life, which is the record label, and then the prosecution is alleging that Young Slime Life is the actual gang. And so they're saying that there was a conspiracy to associate together and with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. And so racketeering is just basically that, a pattern of illegal activity. So you can have racketeering through illegal gambling, prostitution rings, drugs, all these different type of things. So when we're talking about racketeering, we're talking about basically organized crime versus just a one-off criminal situation. So, if somebody shoots somebody, so that somebody shoots somebody and kills them, that would be a murder, and that would just be an isolated incident. But when you have basically a pattern of activity, so if that murder then falls in line with basically what they're saying here, such as preserving, protecting, enhancing the reputation, power, and territory of the enterprise. So that's what they're saying here. So that's basically what they're doing through murder, assault, and threats of violence. All right. So they're also saying, hey, they're preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by posting messages. So the use of social media, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. All right. So basically, the record label side, so the music side would end up being, basically a promotion of the gang is what they're alleging here. So as we get to some of these acts, so we've talked about conspiracy before, conspiracy just being an agreement between two or more people to then engage in criminal activity, whether that's a bank robbery, whether that's murder, whether that's distribution of controlled substances. It's basically that agreement. And then the prosecutor will allege what they call overt acts or steps, taken in furtherance of that conspiracy to commit the offense that is the goal of the conspiracy. All right. And so moving on, I just want to point out a couple of portions of this indictment that are relevant as to Mr. Williams, aka Young Thug, because again, this indictment is 88 pages, and so I don't want to bore you with the details of going through every single page, but just to point out some of the information as we then dive into the issue of his bond. All right, so here on page 13, one of these acts was, they're saying Jeffrey Williams, and this is an allegation that he committed the felony offense of theft by receiving a stolen property. And so when he possessed certain property, a firearm, so he's saying, or they're saying that the property of Ann Williams, then he knew or should have known that it was stolen. So basically a stolen weapon. We also have here, I thought it was worth pointing out here one thing they're saying. This is a different defendant in this indictment, Walter Murphy. So he has this YSL tattoo here. All right. So this photo that was posted on social media, and it's interesting that social media nowadays is really a huge source for law enforcement, basically conducting their investigation, because a lot of times you will have gang members who are opposing for pictures and posting them on social media. And so you see, tattoos with the neighborhood or the sets on, whether it's on their stomach, on their face, or what have you, throwing up gang signs. And so a lot of times when the issue of whether a person is a gang member or not, when that comes up, nowadays, law enforcement is using these images in order to say, yes, this person is a member of this gang. All right. And so, moving on to page 17. So then we have Jeffrey Williams. So we have Young Thug here, and excuse the quality of the photo. That's just, how, how it came through. But they're saying he's an associate of YSL. And they have him wearing red clothing. So they're saying that YSL is basically part of a national group of Bloods. And so you'll see throughout the indictment, they refer to wearing red. So red rags for Bloods, and then green for slime. So green being slime life. And so then you'll see, they're either wearing red or green as part of their association with this gang. And so then they also say, hey, we have Demikion Garlington and Jeffrey Williams, both associates of YSL, posing for a photo saying we ain't going back and forth. And so it's interesting. We're going to end up hearing from the prosecutor interpreting some of these messages. And that's always kind of funny to hear when you have, an older middle-aged white dude breaking down some of these lyrics. It can be kind of entertaining. But basically they're saying, hey, we ain't going back and forth. And what that basically is interpreted to meaning is there's not going to be this talk. We're about action, right? So and one of the alarming acts here has to do with Young Thug allegedly having rented a 2014 silver Infiniti Q50 sedan from Hertz. And so they were saying that car was used in the murder of Donovan Thomas. So again, if we just look at this, we're not talking about just lyrics. We're talking about an actual murder that took place in 2015, and Young Thug is alleged to have rented the car that was used in that drive-by shooting. And so this is where we'll see here. The next act is, between these individuals here that you see that they unlawfully and with malice aforethought committed the felony offense of murder by causing the death of Donovan Thomas Jr., a human being, by shooting Donovan Thomas with a firearm. And then there's attempted murder because there were a couple of other people. There were two other gentlemen who ended up getting shot. I think one was an adult and the other might have been a kid. But yeah, so this is real criminal activity, right? And so as we go on, there's a couple of other ones that I wanted to point out. So page 18, 17 through 20. Yeah, so these murders, this murder and attempted murder, because there were two other individuals who were shot, but apparently didn't lose their lives. And here we have this one. This one was pretty alarming as well. Basically, not so alarming, not as much as some of these other ones, but Jeffrey Williams basically saying 16 days after the murder of Donovan Thomas. So again, he's alleged to have rented this car. Then there's a drive-by shooting in which Donovan Thomas loses his life. And so Young Thug comes out in a video on social media just over 2 weeks after this guy gets killed, saying, so a nigga, they lied to their mama, lied to their kids, lied to their brothers and their sisters, get right into the courtroom and tell the God's honest truth. I don't get it. Y'all niggas need to get fucking killed from me, and YSL. So, this is him speaking on either, witnesses. So witnesses basically lying in the streets. You'd even lie to your parents. You lied to your kids. You lied to your brothers and sisters. And then all of a sudden, when you get in the courtroom, basically you're telling the truth. So him saying that, they need to get killed. It's just, with a post like that saying, just a couple weeks after this murder taking place, this is what they're using. So this is information that's being posted on social media or put in music that they're using that is actually tied to offenses that took place. So then moving on to page 24. So we have, you might have remembered when Young Thug's tour bus ended up getting shot up. All right. So this is actually an allegation in this indictment. So on April 26, 2015, they're saying defendant Jimmy Winfrey did commit the felony offense of aggravated assault with a deadly weapon. So they're saying that, they used a firearm which was used offensively against a person, and it was likely to cause great bodily injury against the person of Dwayne Carter, aka Lil Wayne, by shooting at a bus in which Dwayne Carter was a passenger with said firearm in violation of Georgia law. So basically, they're saying that even this was a part of this grand conspiracy to basically promote, further, and carry out the duties of YSL, of Young Slime Life. Then here we have Jeffrey Williams, again, being an associate of YSL, committed the offense of terroristic threats. So basically, it looks like a person at the mall told him, "Hey, you're not welcome here anymore." And then, Young Thug basically comes back saying, "If you continue to approach, I'll shoot you in the face with a gun." You can't make a threat like that. That is a violation of the law, even if you don't actually carry out that threat. Making that threat, if the person is placed in reasonable fear of their safety, essentially believing that you could possibly carry out that threat, then that's a violation of the law, and it's something that they're alleging as an overt act in this conspiracy. And then the last thing that I wanted to point out in here was basically these allegations, counts number 68 through 71, and so they're actually naming Gunna and Jeffrey Williams here. And basically, they're saying that they committed the offense of theft by receiving stolen property. And then we also have possession of methamphetamine, possession of hydrocodone, and possession of marijuana with intent to distribute. So they're basically saying that as part of this conspiracy, they have drugs. Generally, when you have possession with intent to distribute, we're going to be talking about larger amounts. They don't necessarily specify here the amounts, but generally speaking, if we're talking about possession with intent to distribute, we're not talking about just a small amount for personal use. So these are larger amounts. And so again, I just want to emphasize the point that these are just allegations. And so all of these guys, including Gunna and Young Thug, basically enjoy the presumption of innocence. But ultimately, this is what the prosecution believes, that if they were to put this in front of a jury at trial, that this is what they're going to be able to prove, and ultimately that they'll be able to prove this beyond a reasonable doubt and find these individuals guilty. And so next, we're going to move into the standard for getting a bond in Georgia. And so, but before that, one thing that I want to point out is it's important to recognize that the DA has alluded to this a couple times, that there have already been essentially proffer sessions. So they already have members of YSL who have basically sat down and told them what's going on. So when we talk about, again, when we go back to this thought of is the prosecution, is law enforcement only using lyrics in order to basically bury these guys? That's just not an accurate representation. Why? If for nothing else, because the DA is saying, hey, we've already talked to individuals who've given us information. And so you may be asking, well, how does this end up going down? What happens a lot of times when you have these organizations and you end up having somebody who provides information or who snitches, right? What happens is, they'll get popped for something. It could be something minor or it can be something big. Let's just say, we were talking about this possession of methamphetamine with intent to distribute. Let's just say law enforcement end up getting a search warrant and they go to one of these individuals' houses and they execute the search warrant and they conduct a search. They rip the house apart, right? They're ripping up couches and destroying counters and going through closets, taking out clothes, doing all this kind of stuff. And then they find a ton of drugs. They find a bunch of methamphetamine, right? So that person's going to get arrested, right? They're going to get arrested and they're going to be threatened with the charge of possession of methamphetamine, right? And if it's a large amount and that person already has prior criminal history, then they could be looking at, decades in prison. So they could be looking at 10 years, 15 years, 20 years, just kind of depending on the amount of drugs any other allegations, were there firearms present in the home, and what their criminal history was. So when you have an individual who is facing a lot of time, one way that they can get them to provide information, because, you know, generally speaking, they're going to hold out in the beginning, right? So if you're sticking to the G code, right? If you're sticking to the G code, you're going to be silent. You're not going to say anything. You're a G. This is what you signed up for. You're not talking. But then it gets to the point where, you know, those days are rolling by, right? And the very people who are supposed to be supporting you, they haven't put any money on your books, right? You haven't seen your girlfriend or your wife. Now it's been a few months. You're only seeing them through visits. You're seeing your kids through visits. That's if your girlfriend or your wife even brings your kids to the visit. And the time is ticking by. You know, these individuals aren't putting money on your books. They're not writing letters. They're not showing up. There is no support. And what does anybody want in that situation? Freedom. Nobody wants to just be, you know, detained while everybody else is out and living life. And you're seeing posts on social media, you're seeing videos, you're seeing all this stuff going on. And so then when your lawyer tells you, hey, well, it sounds like if you have information, they might be interested in listening to it. And that's when, you know, ears perk up. Okay, well, if I tell you everything I know, what are you going to do for me? Okay, well, you're looking at 20 years. We'll get you out in 10. We'll get you out in 18 months. You know, we'll get you out in 10 months. We'll get you out in 18 months, whatever the deal might ultimately be. So then they're doing this analysis. They're weighing their options. Do I tell my boy? Do I tell on my boys? Do I tell on my hood? You know, do I live with being labeled a snitch, but I'd be free? Or do I just take this time, how they say, take this time like a G and stay silent? So that is the analysis. That's the thought process that's going through someone's head. And ultimately, it sounds like the prosecution and law enforcement has been successful in getting people to basically tell. And so that's in part where they have their information. So let's get into this bond issue. All right. So let's pull this up here. All right. So getting a bond in Georgia. So shout out to Wozniak Law. It's probably a criminal defense attorney. I just Googled getting a bond in Georgia because, you know, I'm a practicing attorney in California, but every state is different. Every state has their own penal codes and they have their own little nuances in terms of how they do things. I just wanted to look here and see, you know, what are the factors that the judge is looking at when they're making a determination on bond. So here we have getting a bond in Georgia. And so they say one of the first issues addressed in a criminal case is pretrial release, also known as bond. And so as in all criminal cases, the defendant is presumed innocent until proven guilty, like we've been saying before. And as such, the defendant is entitled to have a reasonable bond set in all misdemeanor cases. But in felony cases, a defendant is also entitled to a bond unless the state can show that the defendant, so here's the factors. So number one is a significant risk of flight. Number two is a significant risk of danger to persons or property in the community. Number three is a significant risk of committing any felony pending trial. And number four is a significant risk of intimidating any witnesses in the case. And so what they're saying now is if the state can demonstrate just one of these factors, so they don't have to show all of them. If they can show, hey, you know, there's a risk that he's going to, you know, flee the jurisdiction, or there's a risk that he's going to commit another offense pending trial. If they demonstrate one of these factors, then the judge can deny bond. And so here we have, initially it appeared that there was some sort of jurisdictional argument in terms of the first judge that they were in front of. So apparently they have a division between magistrate judges and then actual superior court judges. So we don't have that division in California, but apparently that's what they had or that's what they have in Georgia. And so when they initially appeared, the magistrate judge, you know, basically deferred to the superior court judge on the issue of of pretrial release. And so they had the hearing. And so what the defense is going to do, they're going to file a motion. They're going to file a motion for a bond hearing. And so they'll generally submit paperwork. So you're going to submit any awards your client has received, letters of support, all kinds of information, basically to show that your client is not a flight risk, that your client, that if he's released, there is no danger to anybody or any property within the community, that they're not going to commit any new offenses, and there's no risk of intimidating any witnesses in the case. So you're going to be presenting information that basically supports that position. And so in this case, we actually had testimony. So we had live witnesses, and I wanted to go through some of the testimony from these witnesses because, the lawyers put together a solid case. I think at the end of the day, there's probably nothing more that they could have done in order to try and get Mr. Williams out of custody. I mean, they threw everything you're going to see. And ultimately, the judge denied bond. But, one of the things that is important when we're talking about this case is, again, and one of the things that the defense attorneys will reiterate is that they're not guilty of anything yet. So they enjoy this presumption of innocence, but ultimately we're going to hear the judge's decision. And so let's just go and listen to the initial argument. I'm just going to take little pieces because, again, this whole thing went on for hours, but the relevant portions I wanted to play for you guys because I think they're good.
May it please this honorable court. First, thank you for all the time to give to everyone.
Actually, let me slow this down a little bit.
Always. Your Honor, on behalf of Mr. Jeffrey Williams, Mr. Adams and I respectfully request, along with the Honorable Avis Hornsby, bond to be set today. Your Honor, I give a case law to this honorable court, as well as the prosecution and Mr. Adams. Mr. Williams is aware of this case law, Your Honor. And the first case I gave this honorable court is Coward, COWARDS versus State. It's 266 Georgia, 191. It's a 1996 case. It's on page 2 or 3 of the copy I've given this honorable court. And the parties, the right-hand side, it's in Division 2. It's 15 lines up from the end of the paragraph, first whole paragraph on the right-hand side. And it reads that the defendant's guilt or innocence of the underlying charge is not an issue at the bail hearing, especially since the defendant enters the proceedings cloaked with a presumption of innocence.
So again, this is important to make note of, because one thing, none of the information that the state is ultimately going to present is going to be a surprise to the defense attorney. So he already knows what's coming. He knows because the defense attorney, as you can see, presents first. So they're going to be basically going through these factors for the judge to demonstrate that that Mr. Williams should get a bond, but he also knows that the state is going to be coming with their evidence. And so he's just, making, this is what we call making a record, right? So he's citing to case law, basically emphasizing, and the judge knows this stuff already, right? So the judge is seasoned. He's not new to this. He's aware of what the law is. But the defense attorney is making his record in order to emphasize, hey, listen, we know what is going to be coming from the state, but bear in mind, Your Honor, that our client is innocent. He enjoys the presumption of innocence. So he's basically making that record, and he's referring to case law. So he's basically submitted a copy of the cases that he's citing to the prosecution and to the judge. And so what case law is when you have a case and it goes to trial, right? So if a person is found guilty, then they have a right to an appeal. All right. So you have a right to an appeal if you're found guilty. And if you appeal the decision and there's some sort of novel issue that ends up going in front of an appellate court and they write a written decision, that can become new law. So that's what case law is. So basically, oftentimes it's interpretation of statutory law, and that becomes new law. And so we can look at precedent in order to, basically make the analysis in terms of the argument that he's making. So he's going through this case law in order to basically set the stage for the argument that they're ultimately going to make.
And then the court explains that in the next lines, skipping 2 lines in the middle, the decision of defense counsel to bring the extraneous issue of guilt or innocence into bail proceedings did not preclude, and goes on to.
I'm not going to consider anyways. I'm that's well settled. That's a well settled premise, Mr. C. We can move on from there.
So again, that's where you hear the judge. Hey, listen, I know what the law is. This is well settled. I think some of the cases they're citing are really old Georgia cases. So in terms of the precedent, we already know what we're dealing with. So he's asking them to move on.
Versus Solano, SALERNO, which is 481 US 739. It's 1987 on page 14
of 20.
Correct.
Okay. All right.
And on the left-hand column, Your Honor, the last paragraph in the Division 3, the highest court wrote, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception.
All right. So you hear him say liberty is the norm. So when we're talking about pretrial conditions, liberty is the norm. So someone should be able to essentially fight their case from the outside. They should not be detained pending trial, because what they're saying is that this pretrial confinement should not be punishment because the person hasn't been convicted of anything yet. So he's just pointing out that a person should be free, and to confine a person or to keep them detained pending trial would be the exception.
We hold that the provisions for the pretrial detention in the Bail Reform Act of 1984 fall within that carefully limited exception. The act authorizes detention prior to trial of arrestees charged with serious felonies who are found after an adversary hearing to pose a threat to the safety of individuals or the community, and this is what I stress, Your Honor, which no condition of release can dispel.
All right. And so what he's setting the stage for is how he's going to present that there are conditions that will basically meet the judge's concerns, meet the state's concerns in terms of these conditions. And they're going to be conditions that are very outside the norm of what a person of normal means would be able to afford. We're going to hear from different witnesses, and you're going to hear stuff that is outside the norm in terms of these conditions that they're creating in order to make their best case for the judge to release Williams on bond.
All right, sir. In Jones versus Grimes, which is GRIMES 219, Georgia 585, 1964 case, it's cited often, Your Honor, on page 3 of 4. On the very top right-hand side, it's in Division 1, the High Court wrote that excessive bail is the equivalent of a refusal to grant bail. And that's what my issue was. I just want to point to court, because in the next case, which is Coleman, COLEMON versus State, 361 Georgia Appeal 901. Your Honor, this came out recently, November of 2021, so maybe 8 months ago. It's on page 3 of 4. It's the appellate court, or second highest court. He's talking about excessive bail, which obviously is equivalent to no bail. And then the court wrote on the left-hand side, on the in the paragraph that is indented, excessive bail is prohibited by the Georgia Constitution and the 8th Amendment to the United States Constitution. For purposes of the 8th Amendment, excessive bail is defined as bail set to an amount higher than an amount reasonably calculated, and this is what I'm stressing on, to ensure the presence of the defendant. When fixing bail in Georgia, a trial judge's foremost consideration, and it's stressed in the text, Your Honor, is the probability that the accused, in this case Mr. Williams, if freed, will appear at trial, and to a lesser extent, which is also emphasized in the text, Your Honor, the accused's ability to pay, the seriousness of the offense, and the accused's character and reputation. A defendant who seeks release on...
So essentially what he's saying is the primary concern ultimately before the court is whether he'll ultimately appear. These other factors are relevant and must be taken into consideration, but ultimately the issue is whether he's going to appear, and ultimately the defense attorney is going to put on all the evidence as basically as much as he can. And even sometimes the judge basically shuts down and says, all right, I don't need any more on this issue or from this particular witness. So the defense attorney is going to make the best effort to demonstrate that, hey, Mr. Williams is going to appear at any and all status conferences, including his trial.
Bail has the burden of showing roots in the community that the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating a witness. Your Honor, if you then look on the same page, on the right-hand side, the last paragraph, again, the court writes, and we're reminded, certainly we are not unmindful of the length of Coleman's pretrial detention and the presumption of his innocence. Your Honor.
All right. And so, and again, going back to this case law, and we're hearing about these case decisions regarding bail. So what probably would have happened in those cases is the person basically, in the same way that we have here, the lawyer submitted a motion for bail, and ultimately the judge denied bail. And so that person would have appealed that decision, right? And so once they file their appeal, so you file a notice to appeal, and then the court issues what's called a briefing schedule, and both sides submit legal briefs. So a legal brief is just basically a written document that's going to be setting forth what your arguments are. So you're citing to the case law and you're making your argument in terms of why the judge basically abused their discretion in denying bail. And then the prosecution is going to submit their paperwork saying, no, the court got it right. He rightfully denied bail. And then ultimately the appellate court will make a decision in terms of whether that decision should be upheld, or whether it'll be, the decision will be overruled and it gets sent back down for further consideration. So what the defense attorney, again, is citing to is some of this case precedent in support of his request that the judge grant bond. So like I said, there are going to be a number of witnesses that ultimately testify at this hearing in support of Young Thug's request for bond. And so we'll get to the first one. The first one is a nonprofit organization or nonprofit organizer. His name is Jamil Mitchell. And so we'll hear from him as he talks about his relationship with Young Thug.
In your community on Cleveland Avenue, tell this honorable court the types of works that you do.
I actually own a nonprofit organization where we have football players and cheerleaders. So we trying to push kids into sports, you know what I'm saying? Trying to get them to do something positive instead of just being around, just running around, doing nothing.
And shout out to all the individuals who do this kind of stuff. I've got a lot of friends who have been coaches and currently are coaches of, basketball, football. These are the type of activities that keep kids off the streets, keep kids from, falling into gang life. And basically when you have a bunch of free time, you have nothing to do, that's when it's easy to fall into, criminal activity. And so these organizations are very important. And you're ultimately going to hear that Young Thug over the years has supported this and many other organizations. So again, when we're trying to, as the defense, demonstrate our client is not a danger to the community, actually, on the contrary, he's actually contributing positively to the development of the community. But that's where they're going with this testimony.
Okay. And do you know the gentleman who is on the Honorable Court's Zoom screen, Mr. Jeffrey Williams?
Yeah, I've been knowing Mr. Williams since he was 13, 14.
Okay.
All right, so that's going to be further credibility. I've known this young man since he was 13 years old. And so that's going to be really powerful, just compared to, maybe I just met him 6 months ago, or, we've known each other for a year. He's known him since he was basically in junior high school. So that's kind of going to go a long way to establish the positive side of Mr. Williams.
Tell us, Honorable Court, the ties that Mr. Williams has to this community and what he does to support the community that you are in.
He actually supports my football team and cheerleading team a lot. He sponsored my football team with uniforms, banquets, buy trophies. When we do barbecues for the kid, that he helps with that. He pays to cook. We did a Juneteenth event one.
So you can see, you know, there's a lot of people with really good intentions out there, but a lot of times these things don't move forward without money. So he's saying, hey, you know, Mr. Williams has donated uniforms. He's paid for banquets. He paid for barbecues. He's helped out, you know, financially in order to help us do what we need to do for the betterment of our community. So this is really good information in support of Mr. Williams.
One year, a barbecue, because we never heard of it. So when we heard of it, we were like, okay, this is our 4th of July. So he helped give me money for that, and we paid the cook. He helped do a lot for the community, really, when it comes to the kids and everything.
And what did he, I'm sorry, go ahead.
Just trying to push positivity with the kids.
And does Mr. Williams?
And so a lot of times, I mean, this is going to counterbalance, again, when we get to the state side and they're pointing out, you know, and we went through the indictment and pointed out some of the information in the indictment, but this is really going to be going a long way of painting Mr. Williams in a much more positive light. And so I talk about this often. When you have a police report that basically makes your client look like a monster, right? And you go through this indictment and all these guys are made to look like monsters. This type of testimony, and again, we know that the judge ultimately denies bond, but this type of testimony is very helpful in being able to show, hey, that your client is much more than the allegations in an indictment. He's much more than the one-sided representation that's put in a police report. So again, you know, this information is really goes a long way to counterbalance the negative information in an indictment or a complaint or a police report.
Williams speak with the next generation of children to do positive things with their life?
Yes, sir. I have him plenty of times where we FaceTime each other. Cause, you know, he moves around a lot. He's an international star. So he FaceTime. I put the kid on FaceTime with him. They'd be excited. They shocked. They'd be like, oh, you really know him? I'm like, yeah.
So how cool is that? So he's saying, hey, listen, sometimes you know, Young Thug will FaceTime me and I'll be on the phone with him. I'll be with the kids. I'll be, you know, with the athletes or the cheerleaders. And that's kind of cool to, you know, have coach knows Young Thug, like, what, you really know him? And then, you know, Young Thug's giving them positive messages, you know, stay in school, keep your grades up, you know, continue to give all your efforts on the field, doing all these things, which are positive contributions, again, to the community.
That's my friend. Like, he'll come to the banquet if he get a chance. He'll come to a game.
And does he also come to the area in Cleveland Avenue?
Yeah, he came there, passed out shoes a couple times, do community barbecues, feed the homeless. One year he came, gave out like 90 pair of shoes.
So again, these are special things. I mean, you know, having done some of this type of philanthropic work, you know, it just is really meaningful. And there's going to be a lot of people who feel very, you know, offended almost by these allegations against somebody who has shown so much love to their community. You know, if you can't afford a pair of shoes and you have this rap star coming, because you say, hey, he came through to Cleveland Avenue, you know, he's dropping off 90 pairs of shoes, he's dropping off food, he's dropping off supplies. You know, if you're in that dark spot and unfortunately just subject to poverty, and someone, you know, comes down from, you know, they see this man on a pedestal. He's a worldwide international superstar, and yet he's coming through to drop off shoes. He's donating clothes, donating uniforms, money. You know, they're gonna look at this individual, you know, almost like a god.
To the homeless and to the kids out there. Like, he do stuff for the community a lot.
How old are the children in the football program?
My crew go from 5 to 13. The 13 is the cheerleaders, but from football it's 5 to 12.
And are there girls playing or a girl playing football as well?
I had a girl last year. Yeah, I had a girl play football last year.
And
That's a nice
the name
touch.
of the organization?
Cleveland Avenue 49ers Youth Organization, Development Organization.
Does Mr. Williams support that organization through the children as well as breast cancer?
Yes, he actually. I told him my grandmother passed away from breast cancer right when COVID hit, and he sponsored my football team with breast cancer uniforms, and on the uniform you'll see his record label logo, because whoever sponsored, we put the logo on there to try to show support.
And what's that logo?
I thought that was a nice touch. Listen, you never know what it's going to be that might just touch the heart of a prosecutor or a judge or someone who's in the position to make a decision on your client's case. So years ago, I was representing an individual in deportation proceedings, and he had a criminal element to his case. I want to say that he had been charged with possession for sale of some sort of controlled substance. He was trying to get his citizenship. And so we were trying to get the government to exercise positive discretion and terminate his deportation proceedings so he could apply for citizenship. All right. So he was working within in the medical field. So I don't remember exactly what his position was, but he might have been a registered nurse or something along those lines. And basically, we were telling his story in the same way that you hear the witness here telling his story and telling how he's interacted with Mr. Williams over the years and basically giving information regarding his positive character. We were able to put, why he went into the medical field, why he was so passionate about healing, why he was so passionate about helping others and guiding them through, through their ailments and everything. Interestingly enough, the prosecutor that was reviewing this case, they had a loved one, and it's been so many years, but they had a loved one who passed away from cancer, and they remembered how much it meant to them that there was a particular nurse who really cared for their loved one and made their transition as comfortable as possible given the circumstances. So it really hit home for that prosecutor that our client was also in the medical field and displayed so much passion in terms of why they did what they did. And so ultimately we were able to convince them to terminate the deportation proceedings so he could become a citizen. So you never know what's going to stick, but it can, the details, the more details, especially if they're really positive, the better. And so that's what they're ultimately getting at in this testimony. So now we've established, and this video goes on for another 15 minutes, but we get the point that, hey, I've known Young Thug since he was 13 years old. He's been a positive figure in the community. He's donated. He's really helped out, and there's a lot of you can tell there's a lot of love and respect for Young Thug. So then they also called this young man, a very impressive young man. His name is Corey Jackson, 15-year-old kid who also testified. Let's listen to his testimony.
But later on that day, after I had met him, I found out who he was as far as an artist, and I found out more about him. And then when I really met him and we made the connection, made the bond, was later on when I was like 10 or 11 years old at the time.
And
so he's 15 years old now. Basically met him back when he was 10. So he's known Mr. Williams for 5 years. And so some of this information that he's going to have is going to be very moving and positive as well. Again, a stark contrast to those allegations that we see in the indictment. This is going to be information, again, to counterbalance that, to ultimately show Mr. Williams is not a danger to the community. There is no risk to potential witnesses or the like if he gets out of custody, and that he's going to show up to his court proceedings.
Were you in, I know it's personal, but were you in poverty at that time, if you know what I'm talking about?
Yes, sir. I understand what you mean.
And where were you living?
And so I like, the how the defense attorney didn't just come out and say, hey, you were poor, weren't you? Or weren't you poor? That's the way he kind of phrased that question just shows emotional intelligence. It's not, and the young man's family is in the courtroom as well. And so, he went about the topic in a very professional and respectful way, because it's not always easy to admit, that you were impoverished, so I really liked that touch.
Well, I'm from Jackson, Mississippi originally, so down there it's called Cromwell Street, Shady Oaks, Christian Brotherhood.
And is your father in the courtroom?
Yes, sir.
And other family members?
Yes, sir.
Okay. Tell this honorable court if Mr. Williams ever took you to where he was raised on Cleveland Avenue.
Yes, sir, he has.
And tell the court what you learned from that and what the purpose was.
Well, at the time, he took me there because I always expressed to him how at me being at such a young age, being able to achieve what I have and have the knowledge that I do have, that's why I started motivational speaking, because I want to inspire the youth and show them that anything.
So that's impressive. At 15 years old, this kid already knew that he wanted to be a motivational speaker, has been speaking to the youth. And what we're going to see is that, you know, him and Mr. Williams have come together and been able to push that forward in terms of him spreading positivity to his peers.
Thing is possible, because you can look at somebody while they're old and you say, oh, that's good, they're doing it. But now you have an example that's your age, close to you in age, that's showing you that it's possible. And Mr. Williams, he took me to where he was from. And he showed me where he came from. He showed me the property that he lived in. And he told me, the saying, each one teach one, which is something that he lives by. He has also helped instill in me that I live by now. Each one teach one. And he told me whatever knowledge you have to be able to spread it, because this is who you are trying to inspire and show them that they can become successful. So that is what he took me there for, and to show me.
So again, we're talking about a stark contrast. You have Young Thug taking this young man to his hood, right? So he's saying, hey, this is where I grew up. This is where I came up. These are the streets that I walked as a youth, and telling him as an inspiration, hey, you have a gift, you have a voice. Each one teach one. You got to go out and spread this message of positivity, and also saying, hey, listen, you know, it's one thing for adults, you know, in their 20s and 30s and 40s, talking to the kids, which, you know, sometimes there's a disconnect. But when we have this young man who's their same age, their same, you know, they're in their peer group, basically giving them these messages of positivity, it's a positive thing that Young Thug has inspired this young man so much to then go out and inspire others.
How he was able to achieve what he has and where he comes from, and what I have to do if I want to motivate more young people like me.
And tell this honorable court whether you have gone across our country talking to other students, people your age and younger at schools.
Yes, sir, I have. I've did different things like different school tours and doing motivational speeches for different organizations like the Boys and Girls Club and different things of that nature, and different youth centers, detention centers, of course, schools. Yes, sir, I have.
And has Mr. Williams put upon you the duty that you have to always be positive and try to get other people not to do crime?
Yes, sir, he has. And
So I like, the defense attorney kind of sliding into his question. Hasn't Mr. Williams impressed upon you, basically getting his statement in there through the form of a question. I like that. But more than anything, shout out to this young man and everything that he's been doing, to be able to go nationwide at 15 years old. They say one of people's biggest fears is public speaking. And so to have this kid at 15 years old, touring the nation, giving talks on, motivational talks, spreading positivity, that's just really impressive. And this kid's an amazing witness in terms of, like I said, the defense. They did everything that they possibly could. They pulled out all the stops in terms of being able to demonstrate that Mr. Williams is not a danger to the community. And on the contrary, he's a positive figure in the community. He's a philanthropist. And so, yeah, this is just another witness who did a great job in that effort.
He has always motivated me in that goal and that mission. He's always showed me that path and always deterred me from anything that could be negative or affect me in a negative way. He always deterred me from that and showed me the right way and showed me a positive way to do anything I have going on.
So boom, again, we have a stark contrast to these allegations in the indictment. And again, now you can see why it's really important for the defense attorney to have emphasized in the beginning. He started with the case law and saying, hey, listen, Your Honor, I know that you know what the law says, but I just want to reiterate and emphasize that Mr. Williams is innocent. He enjoys the presumption of innocence. In fact, his innocence or guilt is not a factor in you making your determination for bond. And so having that as a platform, as a foundation, he's now showing all this positive information in order to make his request. So we're going to move on to, once I heard the information about Kevin Liles giving testimony, I just found that to be very surprising because, it is not, I don't know that I've ever seen a music executive give testimony at a bond hearing. And so that was just really surprising. Mr. Liles gave some very strong testimony. And thing you got to understand, Kevin Liles, I looked up his net worth. Kevin Liles is worth $60 million. Former Def Jam exec, 300 entertainment exec, and a partner with Young Thug. So Kevin Liles gives some emotional testimony in support of, Mr. Williams being released. And so let's go ahead and listen to some of that.
Your Honor, I'm a 54-year-old father of four. I'm kind of emotional because how good this guy is. I have.
So just to start off, in terms of him telling who he is, I'm 54 years old. I'm a father of young children. And he just out the gate saying I'm emotional because of how good this guy is. And again, you're just going to want to continue to keep in the back of your mind the contrast between what they're saying, what's being alleged in the indictment, and this testimony that you're hearing. And this can oftentimes be hard when talking about people charged with crimes in general. A lot of times when they're charged with something that is really serious, people who write letters of support or who would speak on their behalf at sentencing or otherwise would be a witness, a lot of times the information they have is completely different from what's being alleged, because again, in a police report, in a complaint, their loved one is being made out to look like a monster when they could have they could have a heart of gold. They could be the most friendly person in the world, but unfortunately they have just these ugly acts alleged against them, or they're being charged with them. And so it's really interesting to see how there is, two sides to every story.
Morgan State University. I built a stadium in my old school. I have a street named after me. I have all kind of honorary doctorates. I employ probably 5,000 people.
So this is a powerful man. He's received honorary degrees. He's got his own degree, label executive. He mentioned I have 5,000 employees. So this is not just any witness off the street. Kevin Liles is a powerful man. And again, I found it pretty surprising that, that he would show up. But yeah, this is powerful testimony here.
I was the president and CEO of Def Jam. I've been in this music called hip hop for 38 years. And for the life of me, I don't understand why I have to testify the good that hip hop has done around the world.
This is interesting about him saying, I find it, he's disheartened about having to speak on hip hop. Interestingly enough, hip hop is not on trial here. In fact, no one's on trial. This is a bond hearing, but it sounds like Kevin Liles in what he just said is sort of bringing in just the generality in terms of hip hop having such a bad name.
I've also started a company with Jeffrey called Young Stoner Life. And I remember what he said to me: we're not just starting a company, we're gonna change some lives. And that's what he's done. And he's definitely changed mine.
Mr. Liles, how long have you known Mr. Williams?
I was a fan for probably 12 years, but I personally got to know him in the last 10 years.
Okay. And
so again, a long time. 10 years is a long time.
Have you signed, or your company signed Mr. Williams?
Yes, he signed to us. And I hate to say that he signed to us because it's my partner, but we have two deals. One deal is a deal for him as an artist, solo artist, and the other deal is for Young Stoner Life.
And I know.
And again, we're talking about Young Stoner Life, YSL. So this is the legitimate business side of YSL versus the YSL Young Slime Life, the gang.
This is personal, but financially. There's been testimony that if this trial, and I'm not saying the court will allow it, but if it doesn't take place for a year, there'd be over $1 million in expenses just for 24-hour security of police officers to ensure, off-duty police officers' second jobs to ensure Mr. Williams does not flee, does not get types of weapons, does not intimidate a witness.
So we will hear a brief portion of testimony from an individual who will testify about some of the details of the conditions that they were proposing to the court. And so we hear it was going to cost $1 million to have these law enforcement officers basically at the premises. So if Mr. Williams were allowed to be released, he would have actual law enforcement officers versus, private security or anything like that. So actual sworn officers there to make sure that if he's supposed to be confined in the house, that he's there, and that, certain individuals would have to be vetted in order to be able to come to his house, if any. So they were really going to put a lot of money into this in order to demonstrate to the judge, hey, this would be a suitable condition in order to appease your concerns of, safety of potential witnesses, of not committing further crimes, of, this flight risk issue. So he would be confined at home, and we're willing to put up the money in order to, basically pay for this security and pay for these costs.
It's not a danger to community or property in the community. Can he afford, from your personal knowledge and how much money he earns, can he afford that type of undertaking?
Jeffrey can afford it, and I can afford it, so it will be paid for.
And
all right, so they've got the millions, so they got the money to pay for it. It's not going to be an issue to implement these security measures that they're talking about.
You are willing to back him as well?
I'm willing to back him personally and professionally.
I thought that was powerful too. Again, here we have this music executive saying, hey, I back him personally and professionally. So he's testifying under oath, so he had to raise his right hand and say that he'd tell the truth and nothing but the truth. So help him God. And he's sitting here telling the judge, hey, I back Mr. Williams personally and professionally. Again, this is powerful testimony.
Please explain, if you can, and discuss fully how your life intersected with Mr. Williams' life.
My job is to seek out talented people. And I think God brought us together in a very weird way, but I think we were meant to be together. Jeffrey is not just an artist. He's an influencer. He's a person that I think was put here to change the people around him. And he's so talented. He's creative, he's innovative, and he's fearless. He's a risk taker. And those kind of people, I call them change agents. I'm not signing just artists, I'm raising a young man. He looks at me as a father figure. He's not, like I said, we can't limit it to just his lyrics or his music.
Again, this is fascinating as he's describing Jeffrey Williams and saying that, he's fearless, he's an innovator, he's an artist, he's creative. Again, we have just this stark contrast to what's being alleged in the indictment, what the charges are against him and what would ultimately be in the police reports. And so if you haven't already, please get those likes up. If you haven't already, subscribe to the YouTube channel. If you could pop over there under my name, Jamahl Kersey, and subscribe to the channel, I would greatly, greatly, greatly appreciate it. Thank you.
He's a young man, and he will be a contributing citizen to this world. And that's what I invested. And I truly believe this whole thing that people are talking about, it's not him. The Jeffrey I know give me clothes off his back. The Jeffrey I know, I can give him my kids, he can give me his kids. That's the Jeffrey I know.
You mentioned.
So again, they're saying, all these allegations, that's not him. That's not the Jeffrey I know. And that, when you, from the prosecution's perspective, they're going to basically be saying, yeah, he can be, charming and charismatic and friendly and even philanthropic and all these good things. But at the same time, there's another side to him that is a criminal and is the head of a criminal organization that has committed some very serious offenses. Again, those aren't my words. That's just going to be what the position of the state is.
Lyrics. There's been a lot of argument by the prosecution about the lyrics and songs. Can you explain, if you have any insight, what is selling in the rap industry dealing with the lyrics, and why are they being promoted, and why are people wanting it?
Your Honor, you've I don't know how old you are, but
Older than you.
I've been fighting this battle.
You know, that's when you're dealing with serious offenses, you know, allegations of murder, attempted murder, intent to distribute drugs and all these kind of things, and you know people are facing life in prison and the like, you're still going to have these moments of levity. You know, they're joking about, you know, listen, I don't know how old you are, Your Honor. Hey, I'm older than you, and everyone has a laugh. So there are oftentimes, you know, these situations in hearings or even with trials, and you have juries who will have a laugh. You know, these light moments are always fun when those come up.
For over 40 years. It's not new. And it's funny how we're the #1 music in the world now, and they want to bring this back up. Now, we don't argue about any other movies or other genres of music that talk about I ran them over in my truck, or I got drunk and I went and shot him. We don't bring those things to court. But quote unquote, our music, we've been on trial.
So again, I find this argument interesting. I get where Kevin Liles is coming from. And again, you know, we just had in New York the news about Jay-Z, Meek Mill, and other major artists basically fighting against rap lyrics being on trial. And you hear you hear Kevin Liles making the argument that how come no other genres of music are subject to the same scrutiny. You know, you don't have movies that are subjected to the same scrutiny. And I get where he's coming from, but the pushback is going to be where, and again, we'll hear from the state's attorney, but the pushback is going to be that when you're talking about crimes generally, right, that's one thing. But when you have allegations or when you have crimes that are ultimately tied to actual offenses that took place. So again, we went through this indictment. We saw, you know, murder. We saw attempted murder. We saw possession with intent to distribute, all these different acts in furtherance of a conspiracy. It almost, to me, seems disingenuous that we would say that, you know, oh, well, he's just in here because he raps and he raps about violent stuff. Like, no, there is a tie-in to specific offenses that have taken place. So, you know, where I'm at with this, you know, just as a passionate fan and consumer of hip hop, as a DJ, you know, and as someone who, you know, staunchly upholds the First Amendment and right to creative expression and the like, I really think that there is a line to be drawn between being able to rap about, you know, material that is, you know, that could be perceived as offensive or violent content, and having lyrics that actually line up with actual crimes that have been committed. Because I would venture to say that most people who are actually fans of the music, you know, they live, you know, they're law-abiding citizens, right? So, you know, just because you love hearing about, you know, somebody with guns and somebody, you know, who's shot up any and everybody on a record, you know, most people do not commit crimes, right? Most people live just regular lives, and they work a 9-to-5, and they care about the security of themselves and their family and the like. You know what I mean? So we're consumers of this art. However, again, I think most people, if they were being honest, would draw that distinction between what is entertainment and when you actually have lines in music that correspond with actual crimes, including murders and assaults with a deadly weapon that actually occurred.
we're constantly on trial about who we are, what we are, and why we're. And nobody gave us nothing. So we sit here on trial. We talk about lyrics. Lyrics. I don't understand the thing. I'm gonna be here and I'm gonna keep fighting for it because I believe self-expression, and I believe we should protect Black art. We should protect Black art.
And listen, it's you know, I'm sort of conflicted here, but you know, I just think about you know, 50 Cent being one of the hardest, grimiest gangster rappers in the history of rap. And you look at, you know, that first album that he recorded, Get Rich or Die Trying, and there was a lot of violence in that on that album. But you didn't have acts, you know, specific acts that were tied to any of those lyrics. I mean, in one of the tracks, I do what I want to do. I don't care if I get caught. The DA could play this motherfucking tape in court. I'll kill you. It doesn't get more gutter than that. However, again, when he was rapping his lyrics throughout, you know, that whole album, there wasn't really anything. Well, there was nothing that was actually tied to actual offenses taking place. So that's again where the disconnect is. But let's carry on.
And I'm on trial for lyrics. Come on, man.
With regards to Mr. Williams, and the court may not be familiar, where does he rank in, if there is such a ranking, in the music industry?
Objection. That's not relevant to anything.
Shows.
All right, so so he's trying to paint a picture in terms of who Young Thug is, and asks, hey, where does he rank? Because he knows, you know, Kevin is going to come back with an answer that just again elevates him to this status of somebody who is not a leader and founder of a criminal street gang. However, but on the contrary, he's an amazing artist and creative, and so the prosecution objects, and the judge ultimately sustains.
His employment status is part of the Ayala factors, and whether the record company is going to continue to back him.
I think you've already established that to the witness, and his letter can use to potentially be on alternative release.
Okay. You understand that Mr. Williams was charged in 2018 in DeKalb County with a offense involving, he was riding in a car with two other people, and there was a gun and a small amount of drugs in the car. Are you familiar with what I'm talking about?
Yes.
Okay, and you know that case is still pending, believe it or not, but it went up to the appellate court.
So the reason why he's bringing this up is because the witness has to know, you know, it can't just be all, you know, roses and rainbows on one side without knowing the allegations of cases that are actually pending. So that would ultimately be, you know, I've seen situations where a person is testifying regarding an individual who's facing charges, and they say, you know, he's friendly, he's supportive, he's a wonderful person, he's not violent at all these wonderful things. And then the prosecutor cross-examines him and is like, well, are you aware what he's actually being charged with? Are you aware what his criminal history is? And the person didn't know. So it's like, okay, well, if you knew the details of these things, would you still have the same opinion? And so the defense attorney is going, you know, going, I won't say out of his way, but he's taking the time to walk Mr. Liles through this testimony in terms of, yes, I'm aware that there are pending charges relating to weapons possession and the like, but I nonetheless still stand on my position that I back him personally and professionally. And again, this is going to be, you know, heavy testimony here from Mr. Liles.
I don't know. Are you familiar with all that?
Yes.
Everything was suppressed by the Honorable Superior Court judge in another county, and then the state appeal got reversed and it's pending. You're
Yes.
aware of that?
Yes.
Okay. So Mr. Williams is actually on bond for that case.
Okay.
The allegation also entails the fact that when Mr. Williams was arrested at the home here in Atlanta. A search warrant was then executed at that home, and there were multiple firearms. One firearm was allegedly illegal. It turned into like a machine gun. And there was supposedly about 2 pounds of marijuana and some items in, looks like an energy drink, but it supposedly contains either Schedule 2, 3, or 4 drugs in it, codeine, supposedly. You're familiar with that?
I read it.
Okay.
So again, law enforcement executed a search warrant, found some guns, found marijuana, found sounds like some codeine. So these are, this is evidence of criminal activity. So again, if we're just talking about lyrics are one thing, but search warrants actually, execution of search warrants yielding evidence of criminal activity. This is stuff that we need to know. Are you aware of this, or have you only been given the positive side of things? Ultimately, it's to add credibility to what it is that Mr. Liles is saying, because if he has full knowledge of these allegations and yet is still willing to back him, as he says, personally and professionally, then that's going to go a pretty long ways.
Understanding all those facts, the DeKalb County case, current bond, and the search of the home, you're also aware that many other people were in that house at the time of the search warrant, right?
Yes.
Okay. I'd like to ask you the following questions in addition to the fact that we are charging 2 counts in this current indictment. You're familiar with the RICO conspiracy and the gang?
Yes.
Okay. On your oath, would you be willing to back with your own personal property and wealth, or as well as your own company's personal property and wealth, the bond for Mr. Williams, if the Honorable Court wanted a high bond?
Objection, it's asked and answered. The witness actually has already stated that. And I was pretty,
Yeah, he already said
I very clearly heard
he
that.
put up his own and his company's resources, so I'll stand objection.
Would you be willing?
So for me, the judge ultimately sustained the objection because he's already answered that he would that he personally and professionally backs Young Thug and is willing to stand behind him. But I thought that the objection should probably be overruled because it's not necessarily the same question, because now we have the information of pending charges, of evidence of criminal activity. So I think the posing of the question again, are you willing to back him with your own wealth, with your own finances, with your own company, despite these allegations against him? I think that's a different question, but ultimately the judge sustained the objection. But I don't agree with that ruling.
Okay, if it's the same question, I apologize, but I thought it's a different question. You have to understand that you would, if the court wanted to, you would lose that wealth if Mr. Williams violated condition bond. I mean, it's not just go on bond when Mr. Williams in custody, you're released.
I like the calculated zoom in on his face as the defense attorney is really saying what's on the line here. You're saying, hey, if you are backing him in the way that you say you are, this is serious. This isn't just you coming in and saying words that don't have meaning. No, you are actually putting your name, putting your wealth on the line in backing this individual. Are you sure you want to do that?
Court could have you sign as a co-signer on that bond, and you would actually have a lien against your wealth if Mr. Williams violated condition bond. Are you still willing to do that?
Like a son to me. Yes.
Okay. Without hesitation.
Without hesitation.
All right. Do you believe that
and that's powerful, because now we're going to the issue of flight risk, right? So the thought is, Jeffrey Williams is a millionaire. It'd be very easy for him to jump on a private jet and bounce out to France or whatever and never come back. And I don't know exactly what amount of time he's facing in this case, but ultimately the one of the court's concerned in terms of, is he going to come back to face these charges? If there were any possibility that he would be able to just leave and take off, the question to Mr. Liles is, are you willing, if he were to be able to get out of custody, if we're requiring a significant bond amount, that you would be paying this, and you could ultimately be subject to having a lien against your property, against your property, against your wealth are you willing to be that responsible for this other man? And he's saying, hey, I look at him like a son. I'm willing to do that. So again, this was really powerful testimony.
If granted bond on your oath, Mr. Williams would intimidate any witness,
Nah,
obstruct the administration of justice.
no.
So they're asking, do you believe if Mr. Williams gets out of custody, is he gonna obstruct the administration of justice? Is he gonna intimidate witnesses? And he almost laughs when he says no, because in his mind, at least that's what it comes off as. He really can't imagine this happening.
Be a danger to the community or property of the community.
Not at all.
And
So again, he's going through these factors. Again, this is what the judge has to base his decision on. So we were going back to those factors, whether they're a significant risk of flight. Is there going to be a risk of danger to persons or property in the community? Is there going to be a significant risk of committing any felony pending trial? And is there going to be any significant risk of intimidating any witnesses in this case? So the lawyer just basically went through these factors to establish that none of these things are a significant risk.
a risk to commit a crime while out on bond.
No, not at all. He has too much respect for me and too much respect for the company that we're building and too many people that depend on it. It's not about Jeffrey. It's why it's about the family. It's about the community. He understands. He's inspiring the world right now. There's a kid that he changes their life every day. I really believe that.
For the better?
For the better.
I have one last question for you.
And that's probably true. I mean, I'd like to think that if Mr. Williams was released, that he'd probably keep his nose clean, right? Especially with the security detail, with everything that's at stake, it would be very foolish to get out and continue. If he is involved in any sort of criminal activity, it'd be very foolish to get out and continue on with that. You would want to be squeaky clean and make sure that you are not violating any laws, not associating with anybody who's violating laws, to make sure that you don't get taken back into custody. Because I can guarantee you this has been hell for him. He's been detained since May 9th. So we're almost coming up on a month. And so this is an individual who's a millionaire, who, has all the resources in the world, the jewelry, the cash, just everything, the prestige, the way he lives his life. And that's all been at least temporarily taken away from him. So this has been a very difficult situation for Mr. Williams.
If this honorable court granted bond, but it was very, very restricted. Mr. Williams is not coming out to studios. He's not doing videos. Speaking with him may be curtailed. Is your record label still willing to keep him as a vibrant member of SIN?
That's my partner.
And just for the court's edification, I think you just said, but Mr. Williams is not only an artist, he's an owner of the company, right?
He's a businessman. I told him hip hop has given him a way to be an entrepreneur, a way to empower people, a way to educate people. And he has a responsibility. He knows that with this success comes responsibility. And we made a commitment to each other that we're going to do this for the rest of our life.
I want to thank you so much.
Thank you, Ron.
Hold 1 second. Any questions?
Sorry.
Okay, all right. Then I'll.
All right. And so the government had no questions for him. And, at the end of the day, to me, this just was really powerful testimony. Again, we had a young man who is a motivational speaker, 15-year-old motivational speaker. We had the owner of a nonprofit organization, a coach who has a football team that Young Thug contributes to positively, puts up money, all these different type of things. And then we have Kevin Liles, which again, this was just such powerful testimony in terms of demonstrating, that there's no risk in terms of how these factors go. So what the last witness testimony we're going to listen to is the investigator who's talking about some of the logistics in terms of potential home confinement. So again, what they're trying to see or what they're making the pitch for, because generally when you request bond, there's going to be some restrictions, but not like the ones that they're proposing here, because ultimately, without these type of proposed conditions, there's no possible way the judge would let him out on bond. So they're trying to do the best that they can to put forth the convictions or the conditions that are ultimately going to appease the state and the judge. And so here's another example of what they were trying to put together in order to address the judge's concerns.
Confinement purposes. And looking at them from the perspective of a security professional, and in terms of what the staffing requirements might be for each property, and the feasibility of creating a home confinement program, and what those staffing.
So they've actually created a home confinement program, and this is what they're ultimately proposing to the judge, that hey, there is a good alternative to, again, going back to what the defense attorney was saying in the beginning, that liberty is the norm. Liberty is the norm, and a person being in detention is the limited exception, right? And so when we're trying to come up with something to allow him to be released, they're again proposing conditions that are going to be that are going to address the judge's concerns.
Requirements might be for law enforcement, currently certified, post-certified, only law enforcement staffing with regard to a home confinement, essentially program that also would include ankle monitoring, 24-hour, 7-day a week, physical monitoring performed by off-duty law enforcement.
So again, with the ankle monitoring, 24/7, and having off-duty law enforcement surrounding the home or in the home, that's really gonna go a long ways to ensure that if he's supposed to be at home, he's gonna be at home. To the moment that monitor goes off and basically indicates that he's outside of the home, that would be a violation of the release conditions, and he could be taken back into custody. So these are the logistics he's talking about in terms of what they're proposing as an alternative to him being in custody.
Including making contact with law enforcement officers around the state that would be available to perform such a function, that would be authorized by their departments to perform such a function, that are ready to go as we speak today, that are ready to mobilize right now.
So this is already in place. So it's not just something that they're talking about. They've already constructed a plan. It's ready to go. If the judge says, okay, I'm ready to release Mr. Williams, then boom, they already have this ready to go. So, did a great job in terms of putting their client in the best possible position to be released from custody.
And to date, I have secured 24 such officers that are authorized and ready to mobilize for this sort of assignment. The purpose of doing so and using law enforcement only is because they are active, they are sworn to uphold the laws of this state. They would be responsible for reporting any sort of violations that might be committed by Mr. Williams.
So this adds credibility to the proposal, because if it were just, private security, then the thought is, especially from the DA, well, what's to stop him from paying these guys off and just letting him roam free, or letting him leave the country, or whatever the situation is. No, he's saying, no, we have 24 sworn peace officers who are going to, be here around the clock in order to make sure that, he's not committing any violations of any laws, and that he's staying in his home if the judge allows him to be released. So I thought that was a really important touch, and boom, they're a lot more inclined to report if any violation of the law is committed by him or anyone, related to him.
Now comply with the terms of his bond. And so by utilizing active law enforcement only in lieu of utilizing private security or private investigators or anything lesser than a post-certified officer, we seek to provide comfort both to this court and to the state, responsive to the concerns that I've heard. Frankly, I said.
again, so they're making the best case to address the concerns, because as we go back to these bond factors, being a risk of flight. So if we're concerned about him being a risk of flight, if we have law enforcement officers at the home around the clock, then that's going to address that concern of him being a flight risk. If he's subject to 24-hour ankle monitoring, GPS, that's going to be, again, addressing the concern of risk of flight. Having law enforcement officers around is going to make sure that there's no significant risk of committing a felony. Also being addressing the concern of witnesses being intimidated during the pendency of this case. And so yeah, there may have been other individuals who testified on his behalf, but that goes to show. I mean, we had 3 individuals who basically gave testimony that sort of pulls on the heartstrings, right? Showing again that he's a philanthropist, showing that he's a positive character in the community, and then showing that he's a business executive and he has somebody as rich and powerful as Kevin Liles to come up and show testimony and basically indicate, hey, I back him personally, professionally. And then we actually have a private investigator saying, hey, we've created a plan. We already have law enforcement lined up in order to ensure that he's going to remain in the home if the judge allows him to be released. So now let's take a look at the state's case. I'm just going to skip a little because they're actually.
Yeah, you're talking about last one.
Yes, Judge. The next one is going to be Act 60 of the indictment, which is on 3/25/16. It is.
Yeah. So before we get into this, the defense has already put together, or put forth their information, their evidence, and their argument in terms of, addressing these factors and why there is not going to be any risk of those factors that we've already looked at. And the judge has listened to them and taken that into consideration. And now the prosecution, the state, gets their opportunity to show why bond should be denied, why he should be held in custody during the pendency of this case. And this is their case.
It's a music video entitled Slime Shit. And it talks about YSL shit. Killing 12.
And again, it's always funny in these cases, whether it's a gang case or cases where you have this type of slang talk and they have to read whether they're police reports or song lyrics or what have you, having an older white male who is as far disconnected from the culture as you could possibly be, reading out these lyrics and stuff. It's kind of entertaining.
Being a euphemism for police officers. Fuck a jail shit. I'm a VIP and got a pistol on my hip. Again, and I took what Mr. Liles said, and I don't disagree with him. If we have someone singing these kind of lyrics and isn't living this lifestyle before they sing about it, I don't think that's a crime. That's not the case here.
Boom. So there's his argument. He's saying, hey, listen, I heard the music exec passionately say that, he's tired of hip hop being on trial. He's tired of the culture being on trial based on the art. And so he's saying, hey, I acknowledge and accept that. But what he's saying is it's not just general lyrics without anything behind them. He's saying, again, that these lyrics have actual acts that have been committed. They're tied together. So it's not just a case of lyrics being on trial, or Young Thug and Gunna are not just facing charges based on lyrics.
We're basically singing lyrics about what they're doing. The fact that Mr. Liles isn't aware of what his business partner is doing is the other issue. In that song. And
so again, that's what I was going to in terms of the defense attorney was asking him questions to see whether he was aware of the allegations in the pending case and then the allegations from this case, because he's saying, hey, listen, it's possible that Mr. Liles just isn't aware of this situation. So basically, from the government's perspective, this is not just him being prosecuted for these lyrics. He's saying, hey, there are actual crimes that have been committed, and these lyrics tie into actual crimes committed.
It goes again, fuck the police, fuck the judge, mob life. On 9/24/17, Act 68, I believe 69, 70, 71, and 72, Your Honor. This is a act out of Brookhaven Police Department that Mr. Steele spoke of, where Mr. Kitchens and Mr. Williams were stopped in a car based on a traffic violation. And
all right, so he's mentioning, now we're getting into Gunna and Young Thug were actually stopped for a traffic violation.
And a stolen weapon was found in the vehicle, and methamphetamine with intent to distribute, hydrocodone with intent to distribute, marijuana with intent to distribute. And
all right, so we have a stolen firearm. Again, this is a vehicle where Gunna and Young Thug were actually pulled over. So this is not a song about them, being pulled over. They were actually pulled over, and there's a stolen weapon in the vehicle. There's hydrocodone with, in an amount that I'd imagine would be with intent to distribute, and marijuana and another controlled substance in the actual vehicle that they were pulled over in.
And a criminal street gang charge arose from that. And the interesting thing on that is when the officer asked Mr. Williams' name, the response from Mr. Williams was, I'm a superstar. Can't take me to jail.
All right. And so, this is something that they're citing as, when we're talking about, again, a person's willingness to come to trial, something like this, an allegation that he's saying, hey, you can't arrest me, I'm a superstar. This is going to be in support of their allegations that this is somebody who, doesn't respect the law, is not going to be willing to comply with the court's order. And so it just doesn't look good.
The officer did. I think Mr. Williams discovered there that didn't work.
So the DA slides in a little joke, basically saying that, hey, he was actually arrested, so the superstar status didn't really get him very far.
Your Honor, in Act 73 on 12/30/17, Mr. Williams appeared in a video. It was called Original Slime Shit, with lyrics, murder gang shit, YSL till you're dead and pale. Act 74 is a music video on 4/12/18 where Mr. Williams states or sings, I never killed anybody, but I got something to do with that body. That would be our position, is that as the leader of this criminal street gang, Mr. Williams probably has never killed anybody. I don't know that to be true or not, but he probably has others do it for him, as we understand the evidence, Judge.
So that's an interesting point, because again, as some of the public believe that Young Thug and Gunna are only facing these charges because of their lyrics, what the prosecutor is saying here as it relates to Young Thug, he's saying, hey, listen, in reference to his lyric that, I've never killed anybody, but I had something to do with that body, basically saying that ultimately, yes, you did not actually pull the trigger. And the DA here concedes that, no, I don't have any reason to believe that Young Thug, that Jeffrey Williams has actually killed somebody himself. However, him being basically the boss, the number one of this criminal organization, he can have somebody do the hit for him. And so, and ultimately that would be something that if we go to trial, that they would have to prove. And so one of the questions would be, okay, well, how would they prove that? Well, as you'll hear at some point, they do have witnesses who have already given detail regarding their position in YSL and the others around them. So, at this point, they already have received statements from members of this organization who have basically laid out the roles of the other players in this organization, including Jeffrey Williams, and they've basically noted him to be, the head honcho, the shot caller, the guy who gets things done through other people.
Who's that Act 74 music video?
Which one, Judge? I'm sorry.
Act 74, you said.
Act 74
When did
was
you start?
4/12/18, Judge.
Okay.
And again, the way as we addressed it in our evidence, Judge, we essentially addressed that as a confession by a party opponent.
All right. So what he's saying here, what he said is we're addressing that as a confession, basically an admission by a party opponent. All these things that he's reading are what are called hearsay. So they're out of court statements, and what hearsay is an out of court statement that's offered to prove the truth of the matter asserted. So basically, they're trying to use these out of court statements to say that what is being said in those statements is true. And generally speaking, that is not admissible in a court hearing, including a trial. So we're getting into the rules of evidence, and actually law students spend a whole semester course learning what is admissible in court and what is not admissible in court. And this becomes very important because a lot of times, people wonder, why can't certain things come in front of the jury? Well, it's because of the rules of evidence. And so what he's saying here is that the way these statements are admissible as evidence is, so there's what's called an exception to the hearsay requirement. And that exception, or one of the exceptions, is an admission by a party opponent. And so they're saying that, Young Thug, Jeffrey Williams, would be a party opponent in this case. And so his out of court statements can be brought in as an exception to the hearsay requirement. That's all that meant.
In Act 75, Judge, which is another traffic event in DeKalb County. It's on 5/18/18. In prior songs, the defendant sings that he travels with snipers. He travels with a dangerous gang. You can't mess with his people. In this, it was a traffic stop. Two vehicles speeding down the road. Officer stopped them for speeding. Mr. Williams was driving the lead car in a Porsche. I do not believe any weapons or any drugs were found in that car. Mr. Williams indicated to the officer that the people behind him worked for him. The people behind him stated that they worked for Mr. Williams. In that car were 4 individuals, some prior felons, and they were armed to the teeth to include a fully loaded 30-round mag with an AK-47.
All right, so here we have a situation where, 2 cars are pulled over. It's found through the questioning of the individuals that the cars are, in fact, associated with each other. So Young Thug's in the back, or Young Thug's in the front, the other vehicle's in the back. There's 4 individuals in the car. Through questioning, they established, hey, Young Thug said, hey, those guys are, my employees, or they're associated with me. And they say, hey, yes, we're associated with Young Thug. And ultimately they search the vehicle and they find his firearms. So, and that's lining up with the lyrics in terms of, hey, I keep snipers with me, or basically I have protection. Like, we're not just out here unarmed, they're actually rolling around with guns and then getting pulled over, and guns are being found.
I do not believe Mr. Williams got any charge other than a traffic ticket at that time. Again, no weapons were found on him and no drugs were found on him. Your Honor, on Act 78 from 1/15/19, it's a video called Bad Boy. Now, understand at a point, Mr. Williams got into a beef, if you will, with another rapper by the name of Rayshawn Bennett, also known as YFN Lucci. At some point, Lucci's mother was shot at.
So this was really hard to listen to when you find out that someone's mother is shot at, right? So you've probably at some point heard of the beef between Young Thug and a fellow rapper YFN Lucci, And so, you know, it's one thing for there to be beef between two individuals, whether they're gangsters or gang affiliated, what have you. But then once, you know, family members, innocent family members who have nothing to do with beef start getting targeted or what have you, then, you know, it just gets bad. And so this is going to be, I can guarantee this is testimony that will have raised concerns for the judge on the issue of, you know, whether the person is going to be a dangerous community. So I'm just going to roll this back so we can hear the beginning of that again.
Into a beef, if you will, with another rapper by the name of Rayshawn Bennett, also known as YFN Lucci. At some point, Lucci's mother was shot at, and the song comes out with Bad Boy that says, let's see, you better watch the way you breathe around me, for that breath be your last, boy. Smith & Wesson 45 put a hole in his heart, better not play with me. Killers stay with me. I shot at his mommy, now he no longer mentioned me.
I mean, that's the one. I shot at his mommy and now he no longer mentioned me. So again, when you have a situation where you know, yes, that in isolation, you could say, okay, well, that's just a hard rap lyric, right? But when, you know, this gentleman's mother was actually shot at, but then you have a lyric that goes right along with that saying, hey, I shot at his mommy and now he no longer mentioned me. That's what they're talking about when they're saying that these lyrics actually line up with actual offenses that have actually taken place.
Again, we believe that Mr. Williams doesn't sing about random theoretical acts. He sings about gang acts that he's a part of or his gang participates in.
And again, these will be allegations that ultimately the DA will have to prove at trial. So they'd have to prove beyond a reasonable doubt that these charges are true. But yeah, I mean, it just goes to show that on some level, that we're not just talking about empty lyrics and someone being prosecuted just for lyrics. There are, you know, offenses that have taken place behind the scenes that they're alleging these lyrics ultimately tied to.
Following that, Your Honor, in the same year, Act 96 on 8/8/19, Mr. Williams posted on Instagram a post, if you will. It said, IFN or YFN, if ain't like what you do for your mother and your kids, I would have killed you. And that was tagging YFN Lucci. Now,
so he said that kind of weird, but basically what Young Thug had said, it was like, if I ain't like what you do for your mom and your kids, then I would have killed you. And so this was a post on social media and tagging YFN Lucci. And so it just, you know, when his mother has already been shot at, it doesn't really come off as a game or just, you know, posturing on social media. It does sound like, you know, a legitimate beef. And so that's why this is being cited in terms of why the judge should not release Young Thug on bond.
I'll go back and I'll get to that later. But this year, a YSL member attempted to kill Mr. Rayshawn Bennett, aka YFN Lucci, at the Fulton County Jail. That's on video as well.
So now we have an actual attempted murder. So, you know, YSL associates, and again, they're not saying that Young Thug himself actually carried this out. In fact, this happened in a jail. And so Young Thug wasn't detained at the time. So he didn't necessarily have any direct involvement. But what they're trying to say is that, you know, that he would have signed off on the ordering of the hit or what have you, that he, you know, basically would have been complicit or ordered this to take place.
And we can tie that to the gang, and I'll get to that later. On Act 97 from 9/16/19, Mr. Williams posted a video called Just How It Is. There were lyrics in that one as well.
What number is that, sir?
97, I'm sorry. And it said, last N-word tried me, almost got popped at Lennox. Ask the cops, ask the detectives, they know all the business. Ask the cops and detective all the jurisdictions. gave the lawyer close to $2 million. He handles all the killings. Mob business. We know to kill the biggest cats of all the kittens. Also, it should be noted that it's alleged that Mr. Donovan Thomas was the head of the Inglewood family criminal street gang at the time. And irrespective of his position that he might have had in a gang or not in a gang, Mr. Thomas didn't deserve to get gunned down on the road in Atlanta.
So now they're talking about the allegation of the Donovan Thomas actually being killed, being shot to death in Atlanta. So, and then that's where they're alleging that the vehicle, that Infiniti Q50 that Young Thug had rented, was the actual vehicle that was used in that killing. And so when they're talking about in his lyrics, you know, basically we know how to go, or we know to go after the biggest cat. They're saying that, you know, Donovan Thomas was the head of that particular gang. So again, these are lyrics that can be tied, or at least the government alleges that they can be tied to actual killings and crimes that actually took place.
Position or Act 102 judge from 3/12/20. Mr. Jeffrey Williams is in a conversation with Mr. Huey, also a defendant in this indictment. Now, let me set this up, Judge. And you heard part of this last time, that there was the theft of a car by someone in the gang, Mr. Huey, and it belonged to the manager of Mr. Williams. Mr. Williams was upset to find out that it was, and he basically texted his folks to say, give it back. Okay. Now, in that, he responds to Mr. Huey, says, if he don't take it back, he going to die. Followed that, Mr. Huey basically was begging for his life in the conversation. It's very clear that he believed that statement by Mr. Williams.
So when he's saying, you know, he's going to die, what the government is saying is, you know, in response to that, this guy was begging for his life. And that just goes to show that when Mr. Williams is talking about killing somebody or somebody has to die, that's not just, you know, hyperbole, or that's not just talk, that he would actually act on it. And again, these are just allegations. Ultimately, the government would have to prove this at trial, but this is what they're saying in order to basically paint Young Thug as a menacing, dangerous individual, basically in contrast to the evidence that we heard, the testimony that we heard from the defense just a few minutes ago.
In Act 127, Your Honor, from 2/4/21, Mr. Williams is in a conversation with other defendants listed on the indictment, where he stated, YSL rule the world, kid. 24 million on an N-word's head. Y'all just start bringing me the money. Man, y'all stop playing with me. That was in reference to gang activity and basically a evidence that he is in charge and all the money goes to and flows through Mr. Williams.
So that's the evidence. And again, this isn't a hearing on Mr. Williams' guilt or innocence. Again, as the defense attorney put, that's not necessarily the issue that we're dealing with here. And ultimately, he enjoys the presumption of innocence. But the purpose in the state laying out that evidence for the judge was, again, to make the case that Young Thug is dangerous, that there's going to be risk that he's not going to show up to his court proceedings, and that the community would basically be at risk and potential witnesses would be at risk if he were released from custody. And so we're going to get to the judge's actual decision. And here, you know, so we know that he was denied bond. You know, obviously he's still in custody, but we're going to get to the decision and hear his reasoning for his decision.
All right, folks, before I go ahead and get started, whatever the decision is today, this is a forum, a public forum, which all are welcome. However, if you feel that you cannot govern your behavior or have acceptable conduct.
All right, so that lets you know right there that this is going to be a denial, right? So you could just tell by the way he opens the talk that he was going to deny this case. He's like, before I even get into this, And he doesn't say, if you can't control your behavior, because a lot of times, and especially in a case like this, you're going to have people in the gallery, people who are actually physically in the courtroom listening to this hearing. And what can happen is you'll have people reacting to the evidence. You'll have people reacting to the judge's decision. So he's basically laying down the law from the beginning, saying, I'm not going to have people, sucking their teeth and gasping at my decision, or speaking out, or basically saying anything. Basically, if you're unruly in my courtroom, you're going to be kicked out.
Please, you can exit the courtroom and nobody will be the wiser. If you make any outbursts or statements or anything that the law enforcement professionals in this courtroom deem to be inappropriate, you will be removed from the courtroom and maybe subject to other action. So I just tell you that up front, because my deputies are charged with the responsibility of good order and discipline. So whatever my decision is, like it or not, I'll give you an explanation for it, but outbursts were not acceptable, okay? All right. So with that, counsels, I've gone ahead and, based upon what has been proffered and the appellate case law, I should say, has been provided to the court, I'll summarize a couple of different things already that you as counsel for the state as well as for the defense, I'm sure aware of. I'm looking at Coleman versus the state, and that's already been cited. That's 361 Georgia Appeals 901. And I'll quote from that decision, which is...
And again, so he's referring back to the case law that basically governs or is going to guide his decision in terms of how he analyzes the evidence in support of or against the request for him being released.
This comes from our Court of Appeals, Judge Miller, Doug Miller, being presiding judge in that particular case. Excessive bail is prohibited by the Georgia Constitution, Article 1, Section 1, paragraph 17, and the 8th Amendment to the United States Constitution. And for the 8th Amendment analysis, as you all are aware, that 8th Amendment violation would be excessive bail or no bail, or fixing an amount that is excessive under the circumstances.
All right, so there's, if you will, there's some pressure on this judge in terms of this decision that he's making, because he's basically saying that ordering of no bail or excessive bail is actually a violation of the Constitution. So this is, it's a bail hearing, but this is not a small decision. So there's, maybe not pressure, that might not be the best word, but this is not a light decision. So he's realizing that if he unreasonably sets a high bail or denies bail, that could be viewed as a violation of Mr. Williams' constitutional rights. So he has to really make sure that whatever his decision is, that he's backed by the law and that the facts support the decision that he's going to make.
When fixing, for the purposes of the 8th Amendment, the excessive bail is defined as bail set at an amount higher than the amount reasonably calculated to ensure the presence of the defendant. When fixing bail in Georgia, the trial judge's foremost consideration is the probability the accused, if free, will appear at trial. And then the court in Coleman goes on to quote that lesser factors or lesser extent or considerations are the accused's ability to pay, the seriousness of the offense, the accused's character and reputation. I've heard a lot of evidence today about those particular factors in regards to Mr. Williams and his ability to pay, and the seriousness of the offenses and his character and reputation from presented by Mr. Steele, Ms. Hornsby, as well as Mr. Adams. So
he's saying, hey, I've already heard information on his ability to pay. I know he's a millionaire. I know he's got it. If I set a high bail, Mr. Liles testified, he's got it. He's also heard information regarding the seriousness of the offenses. So he's heard from the state's attorney, so from the DA, basically saying, hey, there's actual murders that have been committed. There's actual attempted murders that have been committed. There's been drugs that have been seized. So this is a very serious crime. But then he's also heard the positive information. So he's heard the testimony from Kevin Liles. He's heard the testimony from the nonprofit organization and the young man who testified as a motivational speaker. So he's had all that information. He's taken all that into consideration in issuing his ruling.
I have considered those particular issues. Now, also, Coleman goes on to say that a defendant who seeks release on bail has the burden of showing roots in the community, the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating witnesses. And along with this particular case, the court also has considered the seminal case of Ayala versus the state at 262 Georgia 704. And Ayala gives us the framework in Georgia for the purpose of a pretrial bond is to prevent punishment before conviction to secure the appearance of a person for trial, quoting Roberts versus the state, 32 Georgia Appeals 339. And he goes on to say that a trial court may release a person on bail if the court finds the following. So I have to look at the first thing that Coleman directed to look at is consideration of whether or not the foremost consideration is will he, if free, appear at trial, and then the lesser factors. And these are a court may release a person on bail if the court finds one, poses no significant risk of fleeing from the jurisdiction or failing to appear in the court when required. Two, poses no significant threat or danger to any person, to the community, or property in the community. Three, poses no significant risk of committing any felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny a bond to assist the appellate court in this review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state, 111 Georgia 307, pinpoint 308, very old.
So that's important because he's saying, hey, if I make a decision granting bond or if I make a decision denying bond, that cannot be disturbed unless there is a flagrant abuse of discretion. So what he's alluding to is the appeal. So basically, if they were going to deny bond, or if he's going to deny bond, which he ultimately does, Mr. Williams will have the right to appeal. But when we're talking about the standard of appeal, what's going to be looked at by the appellate court, so the Georgia Court of Appeals, when they look at his decision, they're going to be looking at, okay, did Judge Glanville abuse his discretion in denying bond? And the way they'll make that determination is by looking at these very factors that we're looking at. This flight risk, danger to the persons or property of the community, risk of committing any felony, and the risk of intimidating any witnesses. And as we heard, this is what the judge is making a decision on. And so he's making his record in terms of the reasoning for his decision, such that if there is an appeal, that appellate court can determine whether or not he abused his discretion.
Case from 1903. Now, in regards to considering bond for Mr. Williams, I have considered the first consideration is if free, will he appear at trial, and to a lesser extent, the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight. And I'll state for the purposes of the record and purposes of my decision that I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to prove to a jury's satisfaction beyond reasonable doubt, I should say, that he is guilty of the offense or offenses charged.
All right, so we have the judge, again, acknowledging the presumption of innocence. I realize he is innocent until the state meets their burden of proving him guilty beyond a reasonable doubt.
But however, in this particular circumstance, there have been significant proffers about Mr. Williams as being a danger to the community. In particular, the state's proffer that they have taken proffers from other gang members and people who are in this particular indictment and they're not in this indictment, that he is the leader of the gang.
So there you go. So it's not just the lyrics. Like he said, the state presented information that there are folks in this indictment and folks not in this indictment. Again, folks in the indictment and folks not named in the indictment. So they've already interviewed people who have provided testimony that Mr. Williams is the leader of this gang, right? And that these acts have been committed, basically at his direction or under his guidance, under his leadership. So that's the thing. I mean, when everyone's talking about, okay, well, these are just based on lyrics. No, Like the lyrics are just icing on the cake, if you will, but they have actual statements. So people have already started talking in this case and providing them information, which has led to this particular indictment.
It's dangerous, and if he crosses them, he'll kill them or their families. And the predicate.
All right, so again, fellow YSL members have told law enforcement officers, have sat down, given statements to law enforcement officers saying that Mr. Williams is dangerous and saying that he will kill them if he crosses them, or if they cross him, he will either kill them or have them killed. So again, when we're talking about this comparison or this idea that he's being unfairly targeted because of these lyrics, there are actual individuals who have testified as to the level of danger that they're subject to, or that anybody else might be subject to if this person were actually released to the custody,
Or
released from custody.
View of the state. The concerns that I have are some of the statements that he's made about the threats and to others, and that have been chronicled in particular some of the predicate acts that have been stated for the court's consideration. Whether or not those acts, as Mr. Adams has pointed out, because they have to be proven at trial, is a discussion for another day. But at this point in time, in the aggregate, those particular discussions, in particular, the proffer from the people that the state has talked to already, the group chat that from 2015 starting, anybody goes into a courtroom, tells the honest truth, they'll be fucking killed, pardon me for the language, and this threat is still being talked about. So that is of a concern to the court in regards to the danger to or threats to persons in the community. So
there we go. You know, there is a group chat that they've cited to, and when the judge is looking at people being a risk to people or property in the community and risk to intimidating any witnesses in the case, if you have a group chat, and again, you typing in a group chat, you're not thinking that ultimately that these lyrics are going to be, or excuse me, not lyrics, that you're not thinking that these text messages are ultimately going to be in court or ultimately going to be in a law enforcement officer's file, but there they are, right? And so he's saying anybody talking will be fucking killed. And so the judge is saying, hey, this raises significant concern for me, because if he's saying in this group chat with his fellow YSL members that if anybody talks, they're going to get fucking killed, then if he's released, then the risk is through the roof that is going to happen. And so that's going to be one of the issues, or one of the issues that ultimately speaks to his concern about there being a danger to the community if he's released.
And there's no significant arrest of intimidating witnesses or otherwise obstructing the administration of justice. That is the court's concern. The two major concerns that this court has is danger to persons and threats to intimidate other witnesses and obstruct the administration of justice. So all
right, and so we gotta understand being a judge is an elected position, right? So and sometimes, you know, they're up for re-election, right? And so you don't want to be the judge who let somebody else out on bond. And actually, just putting aside the election idea, if he really has a legitimate concern, which based on the evidence brought by the state, he probably does, he actually does have a legitimate concern for the well-being of the people of his state, of his county. If he were to let these individuals out, or let Young Thug out, and something were to happen to the public that otherwise there wouldn't be that risk if he were detained, then no judge wants to have blood on their hands. No judge wants to feel like, hey, if I would have made a different decision, that somebody, you know, may not have lost their life. Or I don't want to be the person who lets this individual out and, you know, my jurisdiction is subject to more terror and crime and violence. So, you know, you can just hear the position that he's in. Hey, listen, I have this individual who his fellow associates have labeled as dangerous, has labeled as someone who will act out on their threats. And so I'm not going to allow this individual to come out and risk the safety of individuals in the community and the intimidation or threatening of witnesses?
Have some concerns about the flight that I share with Judge Wolf also indicated, but and I'm not going to hold it against him that he is very successful and has significant means. But those two factors in particular, threats to persons in the community or pose a significant risk of intimidation of witnesses, otherwise obstructing administration of justice, the court has considered a number of the predicate statements, and for those reasons in the aggregate, I'm going to deny bond at this time.
So there you go. There's a decision. He's denied bond. It's a relatively short discussion of the basis, but I think there's enough there in terms of what his concerns are. It sounds like, again, like he said, his major concerns were danger to folks in the community and the threats to potential witnesses.
But Mr. Adams, Ms. Hornsby, and Mr. Steele, certainly if you should file any other additional motions or things change, I certainly will reconsider the court's position on bond. It is not lost on me that I have not given your client a bond, but that is my decision based upon what I've heard.
So what he's basically saying is that, hey, I'll give you the opportunity to file any other motions, present any other additional evidence that you'd like, and I'll take it into consideration because I understand I completely denied bond versus setting, a high, even an excessively high amount. He's actually outright denied bond. There's no amount that can be posted in order to secure Mr. Williams' release. He will have to remain in custody until he has his trial. And so his invitation to submit further evidence, to me, that almost seems like an empty invitation because there really is nothing more that they can possibly submit. They had Kevin Liles testify. They had a young motivational speaker testify. They had the leader of a nonprofit organization testify and say how good he is in the community, that he's a philanthropist and that he's a good person, and that he has this multimillionaire in Kevin Liles backing him professionally and financially and personally. What more can they possibly submit in order to persuade this judge? So at the end of the day, as it relates to Judge Glanville, there's not anything else that the defense could possibly put up in order to convince this judge that Mr. Williams should be released. So really, again, I can appreciate that he's saying, hey, you can file any further motions, but there's not anything else they can really throw at this thing.
I certainly appreciate your advocacy on behalf of your client.
Oh, sorry, not to mention the private investigator who took the stand and said, hey, we already have a plan in place where we have 24 licensed law enforcement officers, sworn officers, who on their off duty, basically doing overtime, essentially, will work around the clock to make sure that he stays in the home, to make sure that anyone who's prohibited from coming in the home will not be allowed in the home, to make sure that he doesn't leave, all these things. So really, I mean, I really can't imagine anything else that they could possibly do in order to appease the judge and address his concerns, but it just wasn't enough.
And all of the lawyers thus far who have advocated very well for their clients in this particular position. And
that's always nice. He basically appreciated the efforts of counsel, and especially when you get a denial like that on a motion, on a decision. It is nice to have the judge address the client and say, how hard your attorney worked for you, because it can be, decisions like this. It's tough. It's tough for him to hear. It's tough for him to know that, hey, my trial date, isn't going to be until January of next year. So that means I'm going to spend the rest of 2022 in custody. And so, but to know at least that your attorney did everything that he possibly could, then and did a good job in the judge's eyes, that can be helpful.
I will do my level best to make sure that this case gets tried as expeditiously as possible. And if I can get it on the calendar before the 9th of January, I will endeavor to do so. So anything else at this point?
All right. So basically acknowledging, hey, I know that this trial isn't until January of next year, but if there's any way I can get you a sooner trial date in order to accommodate, just given that, Mr. Williams is not going to be released from custody, then he's making that accommodation. But, in my experience on a case this large, I really can't see the case going to trial this year. It at soonest, it would probably go in January of next year. There's just so much work to do. Listen, all we have at this point, we have this 88-page indictment, but all this evidence that the state was referring to, at some point, they're going to turn that over. If they haven't already, they're going to turn that over to the defense. And so the defense attorneys are going to have to go through all of this information. Again, there's an 88-page indictment, and the evidence is going to be in support of that. So all of those possession of drug counts, possession of firearm counts, the murder count, the attempted murder count. There's going to be all the evidence in support of those charges that has to be gone through, and then there's investigation that has to take place. So there's just no possible way that we're already in June, so there's no way the trial would happen before January of next year. It may not even happen in January of next year. There just may be more time needed in order to get ready for trial.
Tom?
Judge.
Yes.
So I know the court filed, sent an email to, I think, the public defender's office concerning getting defendants who are presently representation.
All right, so they're just talking about other stuff that isn't really worth talking about now. So that's the hearing. That was the bond hearing. The judge denied bond, it's if they decide to appeal, and even before getting to appeal, one of the things that I would imagine probably was a discussion between Jeffrey Williams, so Young Thug, and his lawyer, was the management of expectations. Because the defense attorneys had to have known, these are experienced guys, this is not their first rodeo, they had to have known that there was a chance that the judge would deny bond. Obviously, they were very hopeful. They threw everything that they possibly could at it. Again, with the testimony from each of these individuals, even setting forth a solid plan in place in order to meet the judge's concerns in terms of him showing up to his court hearings and showing up to trial, and then showing how, he would just basically be on lockdown at the home. There's nothing more that they could have possibly thrown at it. The judge wasn't going to hear any more testimony on this. He had already heard enough. But so that would be something that, would definitely need to be a conversation between Jeffrey Williams and his lawyer, that, hey, we're going to do everything that we can to put you in the best possible position to have you released, but there is a possibility that the judge is not going to release you on bond. And what they would have to do, or what he would do, is go through just like we did, right? So just like we went through the factors, he would be telling Young Thug, hey, listen, these are the factors that the judge is going to be looking at. We got to try and show that you're not going to be a flight risk. You're not going to be a risk to danger, to property and people. There's not going to be any felonies. So you're not going to commit any new crimes, and you're not going to intimidate any witnesses. Unless we can, show the judge, unless we can convince the judge that these are not risks, then you're not going to get out. Because remember, we were saying that the state only needs to demonstrate just one of these factors. They don't have to prove all of them. They only need to prove one. And so ultimately that's what the discussion would have been. And so for me, if it were my discussion with him as my client, I would have to let him know, again, we're going to do everything that we can to get you out, but you need to keep your expectations in check, because there is a possibility that you will not be released. Because let's just think about it. If he promised him, oh yeah, we'll get you out, no problem. We're going to put all these witnesses on. We're going to get you out. And then it doesn't happen. Now your client's going to lose confidence in you, might even think that you're lying to them or overselling things. And that's not good either. You want to make sure that you and your client are on the same page, and that they trust you, they trust your advice, And so it can be difficult where you're navigating this managing of expectations, because you're obviously communicating to your client, hey, I'm the right guy for the job. You put your trust in me. I'm ready to go. We're going to do everything that we can, but you just have to understand that the evidence that the state is going to put up is going to be really difficult to overcome just on the topic of bond, right? So the issue in terms of them being able to prove the case beyond a reasonable doubt at trial is another issue, but just as it relates to bond, this is what they're up against. And so yeah, real tough break. But yeah, the defense attorney will then be able to talk to him about what his options are on appeal. So again, the judge made the record because he has to state in detail the reasoning why he denied bond, because again, as the defense attorney said in the beginning, liberty is the norm and a person being detained throughout their case is the exception. And in this situation, the judge indicated why he ruled the way he ruled. So then the next step would be appeal if they decide to file an appeal. And if they appeal, remember that standard that they're going to have to demonstrate is that the judge abused his discretion in denying bond. Now, me personally, having gone through this, listened to the testimony, listening to the judge's reasoning, I don't think that they're going to be able to demonstrate that the judge abused his discretion. I just don't see that here. I cannot say that the judge abused his discretion in denying bond. Now, you could say, hey, I don't agree with the judge's decision because, again, he did, with Kevin Liles and the statement that he gave, basically saying, hey, I back this guy professionally and personally. I'm willing to pay because the defense attorney said, hey, it sounds like it's going to cost $1 million a year just to keep him at home under this confinement program that we're talking about. If you had to pay the $1 million, or if he had to pay the $1 million, would he be able to pay it? And would you be able to pay it? And Kevin's like, yes, listen, Jeffrey Williams, he's rich. He's got the money. He's got the $1 million to pay. And I have the $1 million to pay. And I'm backing him. So that wasn't really a concern. But at the end of the day, it just wasn't enough. And so, they'll if they decide to appeal the decision, I'm sure they can, throw what they have at it, and they'll be able to say, hey, we rolled out the whole information on addressing these concerns, and the judge abused his discretion in denying bond. But I really don't see an appellate court reverse that decision, which ultimately means that young Thug is going to be detained throughout the pendency of this case until they go to trial, which is scheduled for January of next year, but may not even go then because there's just so much that will ultimately have to be resolved before they get there. And so some people, I was looking at some of the comment sections. Some people were saying that the judge, had made up his mind already, had decided before they even got there. And realistically, that could be the case. There are motions that are filed in order to initiate the process in terms of having a hearing. So what'll happen is you'll file your motion, and like I was saying before, you'll attach letters of support. They might have attached copies of his awards and bank statements and all this stuff to demonstrate good character, demonstrate his means and ability to pay any bond set, and any other information to show that these risk factors didn't apply. And so the judge is going to have gone through that information. And then if the state submitted any documents, then he'd have an opportunity to review those as well. And then sometimes when you have a motion hearing on any issue, even bond, when you have a motion hearing, the judge may issue what's called a tentative ruling. So a tentative ruling is, hey, I've looked at the moving papers. So I've looked at your motion. I've looked at the opposition to the motion. I've looked at the reply. And here's my tentative ruling. All right, I'm ruling in your favor, or I'm ruling in the other party's favor, and then you can make your arguments. So I don't get the sense that a tentative ruling was issued in this case, but yes, the judge can already have in his mind where he's going before the testimony. But he listened, and like I said, this hearing went on. From what I understand from the live stream, this thing went on for hours. So there was a lot of testimony, a lot of evidence presented. The judge took that all under submission, took that all into consideration, and ultimately made his decision to deny bond. So this is by no means indicative of what the decision will be at trial, if and when it goes for Mr. Williams. But what is very concerning, what should be concerning to the defense, what should be concerning to Mr. Williams, is that there are a number of YSL associates who have already been talking to law enforcement, who have been giving statements, and that, you know, the strongest evidence ultimately in these cases against somebody is your own, you know, your homie telling on you, basically, you know, being able to really just outline and set forth the actions a person has taken. And so that will, you know, that'll eventually come out to light. So when this case goes to trial, you will hear from these individuals who decided to issue statements, but that's down the road. And like I said, in the meantime, the prosecutor will be providing the evidence that supports their allegations. So these witness statements, the you know, photos, videos, all this evidence in support of their charges. Again, these guys enjoy the presumption of innocence. He's innocent unless and until he's proven guilty at trial or decides to plead guilty. But, you know, for the purpose of bond, it sounds like he is going to be detained throughout this case. And so that's pretty much going to be it. We went through a little bit of the indictment and went through the testimony of these witnesses, heard from the state, and ultimately the judge's decision denying bond. So I would definitely want to thank you for tuning in. I hope this was beneficial to you. I hope that the information was useful. If you could, please do me a favor. If you haven't already, like the video. If you haven't already, subscribe to the YouTube channel. We're just going to keep coming with more and more useful evidence and information and insight from a criminal defense attorney. And if you could, please leave me any suggestions. I'm definitely taking all constructive criticism. I definitely invite and appreciate it. So thanks so much for the support. We'll talk to you soon. Enjoy the rest of your weekend. Peace.